Hello, everyone. I'm Andrew Feldstein, a family law and divorce lawyer in Markham, Ontario, just north of Toronto. I'm the Andrew and Ask Andrew. If you're watching us on Wednesday evening, July 20th, you may be looking at Facebook Live, or you may have clicked on the Ask Andrew button on our website, separation.ca. If you are watching live, we welcome your telephone calls, text messages, and emails, as well as asking us questions on Facebook Live. All the information you need to reach us on is on the banner running across the bottom of your screen. An important word about your privacy. Your privacy is important. If you type a comment on Facebook Live, that comment and your name are immediately available for the world to see, and they remain on the internet forever. If you phone in with a question or send a text or email to the address beside me, that's below the screen, your identity is not public. Please phrase your questions with your privacy in mind. And I also want to say that tonight's show, we're going to be going just until 8:45, as we're using some new technology doing Facebook Live today. In the future, we're hoping to go back to the 1 hour time frame. And the show is also a bit different tonight because it's not just limited to questions and answers. Earlier this month, I issued the latest edition of my white paper series, It's Time for Justice. The title was The Good, the Bad, and the Ugly of Self-Representation. If you come to court without a lawyer, you are called a self-represented litigant. Being self-represented is perfectly legal. You have the right in Canada to represent yourself in court. But I think generally, self-representation is a bad idea in the world of family law. It's Time for Justice explains why, and we'll talk about some of the reasons tonight. The easy way to see the paper is to go to the site. It's timeforjustice.ca. Please call in if you have any comments about your experiences representing yourself or being on the other side of the table from a spouse representing himself or herself. I've got some notes written out about self-representation based on interviews and media coverage after The Good, the Bad, and the Ugly was published. But let's get tonight's show started with a question received by email. And here's the first question that I received by email. My husband has a final amended order from the court stating he has to pay child support in the amount of $1,100 according to his pay. And it shall be adjusted if necessary, commencing in June 2017. We just finished a court case, motion to change against her in February of 2016. That being said, my husband got a posting and is losing approximately $700 in pay a month starting August 16. He has spoken to his ex-wife and has asked for child support to be adjusted according to the table amount. She will not agree. Therefore, we will have to take her back to court again. And they ask questions. One, is this grounds to go after full court costs? Well, I'm going to begin with more the legal question that you've raised, which is that your husband's income has gone down and you want a reduction. You want him to have a reduced child support. This is where you need to be able to look at the court order. Because if the court order said the child support is fixed for the year and you can't change it, you may be stuck with that amount. However, you could argue it's subject to a material change in circumstance and ask for it to be reduced. I always say to people, though, that you have to look at what the dispute is really about. And depending on the number of children that he has, it's an $8,400 difference in income, and how much of that will result in a change in child support. So the court, if you're asking about costs, first of all, you have to be successful to get costs. And secondly, even if you are successful, the court may look at the issues in dispute and feel that the cost should not be significant, taking into account how much money is involved in that dispute. Second question is, can we start paying child support to the new table amount without applying for a motion to change and taking her back to court a second time if she doesn't agree? The answer to that is very clear. No, a court order is a court order is a court order, and you need to follow that court order. It's a relatively fresh court order, but you should be following it as well, because family responsibility is able to garnish your spouse's wages. And if they're garnishing the wages, they'll be able to collect it. So I see it as not being a big deal. The next question you say is that she lives approximately 3 hours away, and the nearest family court to her is approximately 4.5 hours away from us. She is very difficult to deal with and only cares about money. Well, if you are bringing a motion to change and it's solely regarding support, the family law rules in Ontario say you can bring it in the court close where that you reside in or the court in the jurisdiction that she resides in. So that being the case, you can start the next motion to change in the court where you're located instead of her. So keep that in mind. That may be very helpful from your standpoint. You say it's a complete waste of the court's time to deal with this and that your husband will have to take vacation time off work to attend court again if necessary. That's reality, and that's why sometimes you need to look at how much you're fighting about. For example, I'm going to go on very rough math, but if there's one child support on $8,000, maybe around $100 a month in child support that you're fighting about. And there lies the big problem. The big problem is it worth the fight and taking the time off work and the paperwork and the documents, etc. So there can be quite a number of problems when you deal with that issue. I'm going to move to a text question that came in earlier today, and then I'll move back to an email. And the text message reads, does this office, being our office, work with legal aid? Unfortunately, we don't. We don't accept legal aid here. And the next part of the question is, if not, can you advise about how to deal with an ex-partner, common law, who uses stalling tactics, such as not responding to his lawyer for months and then dropping them? This scenario has been going on since November 2015, and I have received zero information or cooperation. I'm definitely entitled to child support and spousal support, as well as a trust. He has not contributed at all since abandoning us in August 2014. He has not worked since 2001. He owns property, including the marital home, where this person and their two sons lives, and the bills are in his name and he refuses to pay. Well, the answer here is quite clear. If somebody's ignoring you, there's nothing you can do or a lawyer can do to make them pay attention other than starting a court application. Because once you start the court application, you're making them pay attention to you because they're going to have to respond. Court process is not going to be cheap. It's not going to be fast, but it is the only choice that you do have at that point. Now, I'm going to move back to the next one will be an email that came in. I like what the person says at the top here because they say, hi, Andrew, great show. So I'm thrilled to hear some people are enjoying our show. And the question is, our marriage of over 20 years has ended. Assets have been split and equalization determined. We are soon going to be negotiating support payments with our mediator. 3 years ago, and for a long time preceding that, my wife was earning twice as much as me. Since that time, she left her stable job for an even higher paying job, worked there for a year, but then got laid off. She had a year of severance this past year in which she took some courses and decided to start her own consulting company. She works probably what amounts to a little more than part-time. She is now reporting her income as a little more than half of mine. The last 5 years, including the most recent T4, show we're making about double. I have supported her through many extra degrees, certifications, and promotions, many of which involve her working nights, weekends, and traveling. I've taken care of our house and two busy kids, all the while working the same stable full-time job I had before we got married. The point being, she has always been about the career and earning and have been making all the sacrifices to spend as much time at home as possible. The kids are now in university. Does she not have some obligation to make more money or at least have an income imputed to her higher than mine? She has chosen her path. I think this is a great question because this really illustrates one of the challenges in family law. There's a lot of gray in your question because you're saying she's not working full time and that she's capable of earning a higher income. I know you haven't included your ages in here, but I see that you're saying you've been married about 20 years. So if I were to extrapolate from that, your spouse may be in their early 50s, they're going to argue that they're in one of those stages of life where it's hard for them to find these high-paying positions. And they're going to argue that they're doing the best that they can be doing. And this is all the work that's out there for them. Now, you have to go from the other side and say, you have an obligation, A, under the child support guidelines, because there's still an obligation to support your kids to maximize your income, and you want to see the record of her job search. And if she's seeking spousal support from you, you also want to see a record of her job search. You may want to say there's a lot more work available for her, and she's going to say the opposite. And this is completely great. You're going to walk in, if you go to court, you're going to walk in front of a judge, and who is the judge going to believe? It's he said, she said. So one of the things I say to people in your situation is you should go on the job search websites that your spouse would be looking at, and you should be seeing what positions are out there. Send her the listings for those jobs and those consulting positions. And in addition to doing that, I would even take it one step further. If you know any recruiters in that industry, try to hire the recruiter to write a report for you as to the wonderful and great opportunities that she may have and how much money she should be making, so that you're putting the onus back on her. Now, you go on in your question to say, I find it inconceivable at this point that I'd have to pay more than her for kids' university and living expenses or pay her any kind of support. I get that. I understand that. And that's why you're in a gray area. And it's a question of one of two choices ultimately. That is, are you going to have a compromise and make a deal? Or you can end up asking a judge to impose a decision on you. I don't know which way it will be for you. The only thing I know judges always say is when they impose a decision, both sides may not be happy. I had a recent event when I was in court, and I knew the judge wasn't thrilled about the issues in dispute, and he warned the parties, if you can't resolve this right now, I'm going to make an order that neither one of you are going to like. And he made an order that was the opposite of what everybody was asking for, to try and teach everybody a lesson going forward. You may not like it when you litigate it with the result you get. So you got to keep in mind, you can put your best case forward. It doesn't mean you're going to get the result you want. Going into mediation, I would take the same. You're asking me, what should you do going into mediation? You need to prepare the same way I mentioned earlier. Get all your ducks in a row, take it very seriously, and try to show the mediator all of the wonderful opportunities that are out there for your spouse. Because the other problem is, you said something right at the beginning of your question, is that you've been married for 20 years. If you end up as a support payor, that is the worst time to be separated, because there's a rule in Canada, if you're in one of the provinces that follows the spousal support advisory guidelines, and Ontario is one of them, that when you're married for 20 years, you may be paying spousal support indefinitely, subject to a material change in circumstance. So you could be paying for a very long time. And it's a good reason for you to try and work at fighting about the issue of entitlement for support, to see that she shouldn't be entitled, because you obviously don't want to get stuck paying for a very long period of time, as you may. Now, I'm going to switch back now to an email that came in just as our show began. And this person says that they've been married for 6 years. He owns a condo with his wife, and they still live in it, but in separate rooms. He lived with his parents before marriage, and then my wife and I lived with them for free for 3 months after we got married, and then they moved into their condo. His name is on the deed of his parents' house with 2 other families members, so 3 names in total on the deed. Is my wife able to stake any claim on this home? It's not my home and belongs to my parents. And it's interesting, because I love these kind of questions, because it's a loaded question. There's a lot of issues there. We start with, your wife is entitled to an equalization of net family property. That means that what you're trying to see is how much your net worth went up during the course of the marriage and how much hers went up by. Whoever went up by more pays half the difference. So if you went up by $500,000 and she went up by $300,000, you went up by $200,000 more, and you owe her half the difference, being $100,000. Now, the problem you get into here is, you would start, and your wife is going to say that that home that you own 1/3 of, that's really your parents' home, should be included in that equation for the increased value. You're going to argue that it's not really your home and that you're holding it in trust on behalf of your parents. Your argument would be predicated on a legal concept called a trust. And if it was your parents that paid for that home, they're going to argue that you are holding it in trust pursuant to a resulting trust. And a resulting trust is a concept that when somebody pays for something, the assumption is they're not just giving it to them. So as an example, if I went out and I was really strange day, and I decided to buy my friend a house for $500,000, which would be hard to get here. But I buy him a house for $500,000 and I give him the cash, and my friend registers the name of it. There's a legal proposition that says, no, it's not my friend's house. It's actually my house, and they're holding it in trust. However, that argument could be rebutted. So your wife would be saying that you could rebut that because your parents gave you a gift. And then you get into all the evidentiary arguments of, was it a gift? Who paid for it? Were the other two family members your siblings? And was it a gift from your parents to the three siblings? Why was a transaction done? Were your parents getting sued so your parents did it to put it beyond creditors? Because if that was the case, then what would your parents have said to the creditors? They would have said to the creditors, it's not yours. And you can't say to them one thing and to your wife something else. So I say it's a great question because there's a lot of facts that play out and it's really fact specific. Okay. Now, after that, I'm going to move back to a question that came in by text. And I apologize for looking down, but I have my laptop with these questions coming in. And this one is, do grandparents have a right to see their grandchildren? I don't get along with my ex-mother-in-law. This is another, I really like these questions tonight because there's a lot to them. It's not a simple yes or no. We start with the proposition that parents will know what's in the best interest of their children, and parents get to make a decision whether the children should see the grandparents. So you have a situation, one scenario, which is different than this caller, where mom and dad are still together, and mom and dad have decided that the challenge here is they don't want one of their parents to see their kids. And when they make that decision, that grandparent may say, I'm going to take you to court to see my grandchildren. And in that scenario, we then end up with mom and dad who are denying them access, and the court will give a lot of deference to mom and dad will probably be successful in resisting the grandparents' access unless the grandparent had a lot of time and a really good relationship, and mom and dad have a really no good reason to deny grandma or grandpa the access. Then we move on to the situation where parties have developed the, how should I put it? Mom and dad have split up, and now one of the grandparents wants access. Well, typically how that happens is, I'm a divorced parent, and if my parents are still alive, my parents would see my children when my children are with me. My parenting time would be the time for my parents to see them. And my ex's parenting time is when her mother gets to see my kids. That seems pretty normal. The scenario where people do get into a dispute is when one of the parents has passed on. And the grandparent, maybe this situation, is the former mother-in-law, former father-in-law. And in that situation, the court has a much greater amount of sympathy for that parent because they can't see their kid during their child's parenting time because their child passed away. And there's a recent decision came down with that where the family did get to see their child, the grandparents and the aunts and uncles, for that very reason, because the child had passed away and you want to expose that child to the other side of the family. Okay. Now I have another text message here that I'm moving through. And the question is, how is it decided who can claim the child tax benefits in a separation? Part of me almost wishes I never read this question because the recent budget has done a lot of changes and we're still reading to see how that recent budget has changed all the tax benefits and credits. But under the old regime, if a child is with you more than 60% of the time, then you're the primary caregiver and it flows to you because you're the caregiver. You can also negotiate to share them. So let's take an example of a nanny. One person's the primary caregiver and gets to get all the deductions. The parent has enrolled the child with a nanny or daycare provider and gets a wonderful deduction. Well, the other spouse who has to contribute to that expense, because it's a special expense, only has to contribute on the amount that is net of tax. So in a way, you get it back there. You can also negotiate these issues into an agreement, but generally speaking, the person who has more child more than 60% of the time for the benefits and credits, not the daycare credit, they get to take it. And you don't, unless you negotiate something different. Now, I see one question here is really more directed. What areas in Canada do you practice? I just practice in Ontario, primarily in the Greater Toronto area, but like most lawyers, I will travel to other areas. But I always say to people, there's a real advantage to hiring somebody who is local to where you are. Number one, they're usually less expensive. And number two, when someone comes from out of town, some judges will look at it and say, why did you hire that lawyer from the Toronto area? You're not part of the local bar. You don't necessarily know everybody. And that can be an obstacle. And other times I've been to North Bay, I've been to Sudbury, been to Milton, London, lots of different places. And some judges have been absolutely wonderful to deal with. Now, my next text message that I have is I haven't been able to meet my child support payments because of the Phoenix pay fiasco with the federal government. Do I have any options to avoid problems? To those of you who don't understand what this person means, some employees of the federal government were paid late. So let's start with, if your pay is being garnished by family responsibility, they're going to get it when the employer pays it. And if your spouse wants to raise an issue subsequently that says you were a little late because the federal government was late in paying you, I think you got a pretty good excuse that a judge would roll their eyes at any lawyer who's going to raise that as an issue. Secondly, your pay is being garnished, so it wasn't you. The next issue is family responsibility typically will not do anything for at least 3 months. So you should be fine. I wouldn't worry about that at all. I think that's perfectly fine. I'm going to take a break from the questions right now, because one of the things that I talked about at the outset of the show was dealing with self-represented parties. And I have some points that I wanted to raise about that. And earlier this month, I was on News Talk 1010, Toronto's biggest talk radio station. And I was on Jerry Agar's show, and he asked the question, as he put it, I know everyone is thinking, he said, Andrew, you're a divorce lawyer. Of course you're against people not hiring a divorce lawyer and representing themselves. What else would you expect? And that's an easy type of question. But here's the way it works. When someone comes into a family court and they don't understand the procedure and the rules, they're at a huge disadvantage. I sometimes have somebody come in to my office and they will have read on the internet and come in and say to me, well, Andrew, I read the Family Law Act and a certain section says a certain thing. And I can say to them, well, yeah, a judge does have the ability to exercise their discretion, but look at the word. It doesn't say shall, it says may. Now, ask me the next question of, in my 22 years of experience, how often have I seen a judge say that, actually make that order? And my answer frequently will be, they never have. And if that's the case, you need to appreciate those kind of nuances. You also will see self-represented litigants will not file their materials on time. They may not understand what a judge is saying. They may unnecessarily take cases to trial. I've had some people, when they come in and they've been representing themselves, they have certain litigation positions. And I've said to them, that does not make any sense what you're saying. And you shouldn't be taking that position. You need to take a more realistic position about your case. And I've been able to get them to resolution for the simple reason that they now can appreciate what the other lawyer or what a judge was saying really did make sense. So it can be very important to teach people what's going on in their case, and it may actually get them to resolution a lot faster. Now, the next thing I wanted to raise is self-represented people becoming disillusioned. And when I do phone-in shows on radio or television, and there's almost always a self-rep question along these lines. Why won't the judge listen to me? People really don't understand it, because a case has to be presented in a certain way. Some people will come into my office and say, my husband or wife cheated. They're a horrible person. They need to be punished. And morally, they're probably right. But practically speaking, what really counts, if it's over custody and access, is what's best for the kids. Equalization of net family property and support are based on rules and laws, and not about saying we should punish someone because of infidelity or the stories, because people, we're all individuals. We all have anger. We all have frustration with our former spouse. I know as a divorced father of two great kids that there's times I'm really frustrated with my ex and I want to shout as loud as I can because she does things that really upset me. But at the end of the day, I would never go to court over those issues because they're not court worthy. Those are everyday issues. And when you're self-rep, you can't appreciate that. So when someone says to me, I want custody because my spouse won't agree to enroll my child in the hockey that my son really wants, I say to them, that problem is going to exist whether you have custody or you don't have custody. Or they complain, he's always 10 minutes late for drop-off. It's still going to be the same problem. It may sound like a small thing because to me, sitting here in my office and people are paying me a lot of money for it, it may seem like a small thing. To them, it's a really important issue because it's constantly just, it's like just turning that knife in their stomach every time. And you have to learn these are issues that aren't going to get you anywhere in a court. And you have to know how to focus things so a judge can understand it. And I often see from self-reps a combination of disillusion and disappointment. And it's also interesting because I had a discussion with one of my associates last week about when you win a motion against a self-rep or you win a court appearance against a self-rep, it doesn't even feel like you were successful because the result was so obvious to the lawyer going in. And you knew if the other side was represented, you would have never had that court attendance. You would have never got the cost award. The people would have never been stressed. Problems typically would go away a lot faster for people. One of the questions I get, and this goes into the same thing, is if one of us hires a lawyer and the other represents himself or herself, won't we save a lot of money? In my view, you're actually going to create so much stress and aggravation in your life. If two sides are actually motivated to make a deal, they will get to a deal much quicker with lawyers, because if the lawyers are doing their proper job, then they're going to find out much quicker what the realistic resolution of their case should be. Otherwise, they're not going to hear what the realistic resolution of their case is. Another issue that comes up is about unbundling, because people will often say, it's really great, Andrew. You think we should hire a lawyer and you're a lawyer and you want to get paid. We can't afford it. Well, unbundling is a new thing. It's a limited scope retainer, and it means someone can hire us to take a specific step in a case. One step, they can ask us to draft our court materials. They can ask us to attend court. So there's different options of what they can ask people, or how should I put it? There's different options what they can ask the lawyer to do on their behalf. Now, why might that be a good thing? Well, I equate it to driving a car. If you want to be in the safest car on the road, which somebody may say is a Mercedes-Benz, well, everyone would love to have a Mercedes-Benz if they don't have to pay. But there's still other options that are better than walking that could be perfectly safe. Well, unbundled legal services is a similar idea. It would be best to hire a lawyer right across the board. But if we can't hire a lawyer right across the board, then what can we do? Well, what we can do is hire them to take this one step. And in some cases, when people have hired me for one step here and one step there, I've been able to get them to a resolution and get them through things in a much more efficient way than the situation they're in at that time. Now, another one is about dragging out cases, and I think I've touched upon that earlier, and that is, I hear a common question from a lot of my own clients and the clients from other lawyers who face a self-represented spouse. Why is everything taking so long? If you're dealing with someone who doesn't know the process and doesn't know what they're doing, things invariably take longer. Regrettably, that's just the way it is. And that's life. And when that happens, things are more expensive. They don't understand the process, more court appearance, more documents. And unfortunately, the more work a lawyer has to do, the more we charge to our clients. That's why I always say to people, if you can get two reasonable lawyers working on a file, you're going to do much better than you are in the alternative. Now, a lot of times I will have clients come into my office and they say to me, well, that's just not right. It's just not right what's happening. You should do something about it, Andrew. Well, that's what it's time for justice is. We are trying to do something. But people have to remember, we're lawyers. We're not politicians. I'm not an elected official. I'm not running for elected office. And if you really want to do something about it, that's where you need to go to your MPP. You need to go to your MP. And you need to say, we need to make this a better system. And in fact, judges are trying to make it a better system. They work very, very hard to try and make it a better system. And people need to understand and appreciate that. Now, the next question that I had, because those are some of my thoughts on self-represented people, I'm going to go to another question that we received, and this one was on Facebook. My ex had convinced my son that he doesn't want to see me. He's 8 years old. Do I have a right to see him? The answer is yes, you do. An 8-year-old is nowhere near the age of saying to a parent, I don't want to see you. There's nothing more hurtful or difficult for a parent than losing the relationship to a child. And if you're facing this situation, the reality is you need to go to court, and you need to go to court very fast. The other side will say, well, my child says, well, that's nonsense. An 8-year-old doesn't know that. And the question that judges and lawyers will ask the parent to your 8-year-old, it's a really simple question. What would you say when your 8-year-old says in the morning, Mommy or Daddy, I don't want to go to school? Parent makes their child go to school. Well, when you have an 8-year-old child, you make them see the other parent. And you need to get to court, you need to go to court, and you need to go to court as soon as possible. The problem you may face in that court action won't be just that your 8-year-old is saying that, but the problem is going to be, there's going to be a lot of finger pointing at why this is happening and roadblocks to stop you from seeing your child. I will tell you that in my experience, judges and the social workers involved in the court process are all going to want to see children seeing their parents and having a relationship with their parents. The problem for you is the cost. If this person makes you go to trial, this will be a very, very expensive process, and you need to know that. But if you want to see your child, you should be going to court. I know if I was in a situation like you, I would have zero hesitation, and I would immediately proceed to court on that kind of issue. The next question I have here is, can a divorce be challenged? If you are not happy with the outcome, if possible, will the appeal take a long time? Well, yes, you can appeal a decision. However, that's usually a trial decision. Cases resolve themselves in two ways. The first way is the parties reach an agreement. And if the parties reach an agreement, it is very, very hard for you to reverse that agreement. What do I mean? Well, to appeal an agreement that's reached on consent is extraordinarily difficult, to the point I think I'd almost call it impossible, unless you move to set it aside, which is not an appeal. Why would you set something aside? Well, I'll give you an example. In family law, both sides have to give full, frank financial disclosure. So let's say your spouse left out the fact they had $1 million in an offshore bank account on their financial statement. Well, they perjured themselves and they committed a fraud. If they did that and you found out about it, you could go back to court and say, well, hold on a second. I want that deal set aside because my spouse forgot to tell me about that $1 million. That's an easy one. That's an extreme example. There are other situations where you're not going to get that. Now, the other place where if you don't like the decision, you can appeal. So let's say you went to trial. The judge made a decision at the trial. And after the judge's decision's rendered, you receive it, you don't like it, you can appeal it. but there are strict timelines and procedures for an appeal that need to be followed. And if you are going to appeal, quite frankly, you should hire a lawyer for the appeal, because an appeal is very, very technical, and you cannot just appeal because you say, I don't like the judge's ruling. There's complex rules to appeal. And I'm going to give you a little bit of information about appeals that's important. When a judge writes their decision, they can make findings of fact. So if a judge says, I find as a fact that the husband or the wife can actually earn more money than they are, and I find as a fact that they have the ability to earn, let's say, $150,000 of income, those may be findings of fact. And you can't appeal the findings of fact unless they're unreasonable findings of fact, because you can only appeal on an error of law. So you have to find that the judge misapplied the law. That could be a very hard test to get over. And often when people come to me for an appeal, I'll write an opinion letter before I do the appeal. More times than not, I tell them, you don't have an appeal because the judge has written this in a very intelligent way, and you're not going to be successful with that appeal. Now, another text message just came in, and it reads as follows. Andrew, how is spousal support determined as to which level one will pay? If one is paid hourly and will not be able to work the overtime they did in the past due to inability to find childcare at odd hours, can this be factored into a decision? Yes, it can. A court will accept the fact that now you're separated spouses and you may not have that other spouse available, and that your hours may be a little more limited. Now, there's always going to be a question whether you're manufacturing your rejection of overtime hours, whether you really don't have that extra ability to get the work. There's always going to be questions like that. So when I say a question, I answer a question here, you have to realize the other side may raise other issues, because if the overtime's available and you can take it, you should be taking it. And if the other parent's in the picture, well, there's days when they're going to be available. So there's always some gray. One of the questions here is, how long must one pay spousal support? Well, you heard me earlier in the show, I mentioned that if you're the payor, a horrible rule of 20. See, I'm one of the lucky people because I was only married for 14 years, so I was able to negotiate an end date. I look up at the sky every day and say, thank you for that. And I can tell you exactly how many months I have left. But kidding aside, we all must realize that in some situations you can be stuck. Now, we start with what does the spousal support advisory guidelines say? And the rule of thumb is a half a year to 1 year for every year of common law and / married that you were together. So if you were together for 10 years, it would be 5 to 10 years. Now, there's some exceptions to that. If you have a young child, it can be stretched until they finish high school. So it can go much longer that way. And in addition to that, just because there's an end date in the spousal support advisory guidelines doesn't necessarily mean a court will give you an end date at the original review. They may make an order saying it's subject to a material change, and you'll have to come back and argue for the end date at a later time. The other rule to be cognizant of is the rule of 65. And the rule of 65 is just as bad as the rule of 20. And what the rule of 65 stands for is providing you were together for 5 years and the recipient of spousal support's age and the number of years that they were living together and married add up to 65, it's indefinite spousal support. And it's really important, and it's funny because sometimes I'll have, really not so funny to the payor, but I have clients come into me in my office, and it could be a man or a woman, and they say to me, Andrew, I've been together for 18 years now. Is there any difference if I wait another couple of years? And I have to tell them about the rule of 20 or the rule of 65 and how it applies to their particular case, because they're getting really close to that deadline. Now, these kind of rules of indefinite spousal support are subject to a material change, and people can retire, but there's typically going to be a fight about whether the retirement was reasonable or unreasonable. And now I'm going to move on to another question here, which is, I love my canoe. When I got married, my wife was able to use her family's cottage whenever she wanted. It was her family cottage ever since she was born. Over the 8 years we were married, my wife and I spent quite a bit of our own money on fixing up the cottage, even though it still belonged to her parents. We did not pay any attention to what would happen if we got divorced, which most people don't. One of the things we bought was a beautiful cedar canoe. We always spoke of it as my canoe, and I was the only one who ever used it regularly. Now our lawyer says a canoe is part of the cottage. Am I out of the luck? Well, I'm going to start with saying it's a canoe. You may have loved it, but it's a canoe. And if I had a client who paid me money to go to court and try and argue for a canoe, it wouldn't work. I'll never forget, early in my career, I was in court on a matter where one of the children had maybe 100 or 200 dolls. And I was acting for the wife, and all the dolls were at the wife's house. And the husband starts arguing that he wants his half of the dolls at his house for the daughter. And the judge turns to him and says, you know what, sir, you might be right. But how much are you paying your lawyer to be here right now? And how much time, this is after his lawyer did a 10 or 15 minute spiel about the dolls. She said, how many dolls do you think you could have just spent in the time it took your lawyer to raise the issue about the dolls? So the point is, it's the same with a canoe. It may be a $2,000 canoe, which would be a pretty nice canoe, a lot nicer than mine, but it's not worth paying a lawyer to deal with. Now, I'm going to take one last question really quick, and then we're going to be finishing up because we're almost done for tonight. And the question is, are child custody rules the same for common law and divorced couples? Very quickly, common law couples, custody and access is determined by the Children's Law Reform Act. That's Ontario legislation. And married couples are typically governed by the Divorce Act, which is federal legislation. Both tests are subject to the best interests of the children. The Children's Law Reform Act lays out what that can mean to a certain extent. At the end of the day, judges will look at it the same way, and they'll actually look at the factors in the Children's Law Reform Act in Divorce Act cases as well. Now, regrettably, our time tonight for Ask Andrew is almost up. I hope that I've got you thinking about self-represented litigants. Regardless of who you have as a lawyer, or if you decide to represent yourself, please remember to keep in mind the catchphrase that influences family court judges more than anything else. And I just said it a moment ago, the best interest of the children. And when you go to court, I really want to say this, is don't talk about my rights. My rights. Too often clients will come in and say my rights. When it comes to the children, you need to realize you really have no rights. What you have are responsibilities to your children. You have a responsibility to trying to make the best possible life for your children you can. So don't go in and say it's my right to see my child today or tomorrow or that day. No, it's the best interest for my child to see me and have a regular relationship with me if I'm the dad and with the mom. Because children who have a positive relationship with both sets of kids will do much better than children who are in the middle of a high conflict case. Now, I suggest to people that you read The Good, the Bad, the Ugly, and Self-Representation on itsTimeForJustice.ca. That's our recent white paper that was just released. You can also learn more about family law by visiting our website at separation.ca. Some of you may be watching that on this website, and I think we have a ton of information there, and I really encourage people to go read our our website. And that's it for our show for this month. We'll see you in August. You can see on our website and our social media what day in August our show will be on. And I'm divorced myself, and I want people to know that in August, lots of people are going to be taking family vacations. Enjoy your time with your kids. And be reasonable when your former spouse is asking for vacation time as well. Thank you very much and have a great night.